Next, we have Senate Bill 18. Senator Clark, you are recognized. And Senator Clark, you have an amendment that has been passed out to members. Would you like to explain the amendment first? I think that might be beneficial for not only for our members, but for some in the audience.
Yes, I'm going to ask, with your permission, Madam Chair, to have Representative Gazaway come help.
Yes, Representative Gazaway, come forward,
And
please.
if I could get a copy of my bill.
We'll bring that out to you.
Thank you.
Okay, you may proceed with the amendment.
Representative, would you like to explain the amendment? Thank you.
Madam Chair, has the amendment been passed out to the committee?
Yes, it has.
Okay, thank you. What I would like to do as we begin, the amendment is pretty extensive and essentially is now the bill. And so I would just ask that we adopt the amendment. And if once the amendment's adopted, instead of discussing the amendment, let's just adopt the amendment and then we can talk about the bill itself. I'm not on the committee, so I don't guess I can make a motion.
We have a motion to adopt the amendment. Is there any discussion? All in favor of adopting the amendment, say aye. Aye. Opposed, say no. The amendment is adopted.
Thank you, Madam Chair. Do you want to start?
I'll start. I'll let Representative Gazaway, being the lawyer, do more of the explaining. But when I was approached about this bill, I have had over the past few years, and especially the last two, numerous folks get hold of me. And it's fathers who often are beyond reproach, policemen, veterans, former law enforcement, who are struggling to have some active role in their child's life, and finding that to be a great difficulty. If I have watched the system over the last few years, what they have told me mirrored what I have seen, in that the system, and I think we have one of the best systems in the world, but has failed to value fathers. And the 40, 50 years ago, maybe 30 years ago, I would have favored a system that said that custody went to the mother unless certain other things happened. But things have changed a great deal. The way that people split up has changed a great deal. And one of the things that I talk about when I discuss this subject is after the Jonesboro school shooting, and I don't know how many years ago that's been now, a young contractor and friend was in our store, and we were standing there, and he said, "Alan," he said, "I hope my son never does anything like this." And I said, "Aaron, your son will never do anything like this." And he said, "How can you be so confident? How can you be so sure?" And I said, "If you check the records, and there's been lots of school shootings since then, and it's still the same, almost all, not all, but almost in all cases, there is no active father in the situation." And even when, I'm talking to people on a regular basis, people talk about, well, but someone's better about doctor's appointments or so on. And, this is not about either parent not being valued. I was running for office. I had a very tough decision to make, and I went and met with my mom and dad. But for that question, it was my mom who I wanted to give me an answer. And so it's not about valuing one over the other, but the system has valued one over the other, and they perform two different roles. And so we've moved to a system where the majority of people support joint custody. Children who have grown up in homes where they were split favor joint custody by overwhelming numbers. But our courts have not. And we passed a bill, Representative Lowry passed a bill in 2013 that said would favor joint custody in Arkansas. And turns out that when I presented this to the Senate Judiciary Committee, you should have a handout that's at the top is handwritten, says Arkansas Circuit Court's Judicial Bench Book, Domestic Relations Division, updated June 2018. If you look down at the asterisks, it says in an action for divorce, an award of joint custody. First, what is the Judicial Bench Book? And I'm going to give you my description, layman's description. Shorthand version for judges where it's easy to look up laws without going to the extensive law library. Here's the basics. In an action for divorce, an award of custody is favored in Arkansas. However, case law, both before and after adoption of code provision above, indicates that joint custody is not normally favored unless circumstances clearly warrant such action. Now let me go back up to where we, to that first asterisk. In an action for divorce, an award of joint custody is favored in Arkansas per 913-101A. That's what the legislature passed. However, case law, both before and after adoption of code provision above, indicates that joint custody is not normally favored. That's not what the legislature said. So some will come later and say this bill is not needed. Well, let me tell you, I got an email that weekend from AOC. I work a lot with AOC as Senate Chair of Judiciary. Appreciate them a great deal. And they said, Senator, we apologize. Now keep in mind this law was passed in 2013. We apologize. We've updated the Judicial Bench Book. So I went on the floor and I read what it said then, and it still said, in an action for divorce, an award of joint custody is favored. However, case law, both before and after adoption of code provisions, indicates that joint custody is not normally favored. So I said that on Senate floor. So I got another email. Said, we've changed it again. So I'm glad they have. But the people's branch represents the people and what the people want. And the people want us to start at joint custody and go from there. That's what we've wanted. That's what we've had in law since 2013. I was contacted by judges and by the Bar Association who said, bill's not needed and it goes too far. And so we began to talk, and we talked for several weeks, and I asked for amendments and asked for changes. And we now have in the law you'll have to help me, Representative Gazaway, I always forget the words, preponderance of evidence, which means just slightly more, which means basically a judge can just decide this is what they want to do. And we are changing that in the law to clear and convincing evidence, which they say, well, that you'll have to have experts and so on. Now, we'll have lawyers testify on the other side that says that's not true and it's not that hard. I'll tell you, if you ever think your taxes are too high, the law says that to change it, you have to have clear and convincing evidence. So we worked with the judges and worked with the Bar Association. And other than gutting the bill or not running it, we couldn't come up with anything. But we talked to a lot of other lawyers who saw this going on, family law attorneys across the state, outside Pulaski County, and they told us something different. They said, we absolutely need the bill. Judges are not following this law that says that joint custody is preferred. We absolutely need it. We do think there are some things that need to be changed, and including maybe that wording is a little strong. And so we worked with them. When we couldn't work with the Bar Association, we worked with them. But we really satisfied everything that we were told in the amendment that we offered you today, that we put in the bill today. The biggest disagreement that we had was the modification of current custody. And we were told that the problem with that is that the courts would be overfull with people coming, trying to redo their custody cases, etc. There was some disagreement on that, and some of the people who very much support this bill, that was important to them because they would like to go back to court. But this is so important to them that they were agreeable to take it out. So modifications is no longer in the bill. It's only initially when you go to court. The other biggest problem that we were presented was that clear and convincing evidence was too much, and we were especially presented with cases with physical abuse and sexual abuse, and those parents will end up with joint custody because it'll be too hard to have clear and convincing evidence. So we changed that, although they never offered us anything to change it. We changed that in those cases, and it's lined out here, and Representative Gazaway can explain where and how. It's lined out here that in those type cases, that it will be a preponderance of evidence, but with everything else, it will be clear and convincing evidence. So we covered everything we were told that was a problem. I am sure they're quick on their feet, and I'm sure that they will have new problems today. Because it became evident that they didn't want the law changed. But the law needs to be changed. And we need to start with joint custody. We need to recognize both parents as equal. And we need to enforce that. And then we need to start from there, because joint custody is not the right thing for everybody. We're not saying that. We don't believe that. It's just the right place to start. You'll hear arguments, like I said, from attorneys from both sides. You'll hear from people who have been affected by what we're doing now. And when we're done, I hope you'll be convinced that this is one of the most important bills of the session and something that we strongly need to do. Representative Gazaway.
Thank you, Senator Clark, and I think he did an excellent job kind of summarizing where he came from on this bill. To begin, I think some historical context is important, and so I'll try to give you some historical context about what the state of custody laws have been in the state of Arkansas, and then also in my nearly, at this point, 15 years of practice, what my experience has been in the courts handling lots of these cases over the years. First of all, let me say that for many years in the state of Arkansas, the standard has been and still is what's in the best interest of the child. Okay, that is the standard in any joint or any custody case. What is in the best interest of the child? But for years, the way that was interpreted, including long before I ever started practicing law, was that in a custody case, one of the parents was going to be awarded custody and one of the parents was going to be awarded visitation. And in fact, the case law in the state of Arkansas said that joint custody was expressly disfavored. In other words, it was not favored for judges in the state of Arkansas to award parties who were involved in a custody dispute to award them joint custody. And that was the law in this state and the practice in this state for decades. In 2013, the legislature, I think very wisely and probably beyond time, well past the time that this change should have been made, followed other states in recognizing that joint custody in Arkansas would receive favored status. And so in the custody divorce statute, what you saw from the change that the legislature made was it was reversing those decades of case law that said that joint custody was expressly disfavored, for the legislature to come in and say, no, joint custody in the state of Arkansas is favored. And again, the reason we did that was to reverse decades of existing law that had said joint custody was disfavored. And that was a very substantial step. That was a step in the right direction. It didn't get us to where we should be. And other important historical context to note, there used to be in the law a maternal preference with what they called the tender years doctrine, which was that young children should be awarded to the mother. And that was the law of this state for many years. The legislature abolished that and said that both parents should be treated equally with respect to child custody, and the tender years doctrine has been abolished, and that no longer applies. Since 2013, joint custody has been favored. But I will tell you, from my experience in practice, and this is when I started in 2006, when I took a custody case in 2006, this was just the fact and the law. If I went to court representing someone with custody, there was not going to be any joint custody with the vast majority of judges. Again, as I said earlier, when you walked into that courtroom, you were either getting custody or you were getting visitation. But there wasn't going to be any joint custody unless the parties settled on it. And in 2013, the legislature made that change. Since 2013, things have gotten a little better. But I don't think that we're where we need to be. There are people who are here to testify today, other attorneys, litigants who have had these cases in the courts, who say even when the legislature said that joint custody should be favored, in practice, it hasn't been. And one of the things that I think is striking and quite alarming, really, is what Senator Clark mentioned about the bench book, which is we're the legislative body who makes policy decisions for the state of Arkansas. And in 2013, we made the policy decision that joint custody should be favored. And we were telling the courts at that point, courts, we are telling you that joint custody should be favored. And that's based on mounds of research which says in cases where joint custody will work, it is far better for the children. And some of you should have a book here. It should have been passed out to the committee, but it has research study after research study which indicates that joint custody is better for children because children, even with divorced parents, and this is what the research indicates, children, even with divorced parents, do better to have two parents who are actively involved and engaged in their life. And under the system as it's been for years, when a party gets visitation, let me tell you what the standard visitation order is. It's every other weekend and one weeknight a week, okay? And on varying weeknights, it's only for a couple of hours. And I don't have the exact total, but basically, under the old system as it's been for decades, we have relegated parents, and in many cases, parents who wanted to be involved in that child's life, who wanted to take an active role as a dad or as a mom, but the courts didn't let them, and we relegated them to visitor status in the life of their child. And I'll tell you, we look around at society today, and you wonder, what's the problem with society today? And I will tell you, the courts bear some responsibility in that because they relegated good parents, decent parents, people who wanted to be fathers to their children or mothers to their children to visitor status, and that is wrong. And in 2013, the legislature recognized that, and we said, no. As a policy decision, joint custody is going to be favored. Now, in practice, I can tell you, because I still practice family law, I have open family law cases right now, that in practice, that is still not always followed. It's getting better, and you'll hear from some of the witnesses who will tell you, especially as the older judges who still kind of have that older mindset, as they move off the bench, and as you have younger judges come in, they're recognizing more and awarding joint custody more. But it's time, and what this bill would do is say that as a state, we took a substantial step in 2013 to say that joint custody should be favored. Now it's time that we say joint custody is where we're going to start. When you step into the courtroom, if this bill passes, and this is what we call the rebuttable presumption. So if you look at the first part of the bill, in an action concerning an original child custody determination in a divorce or paternity matter, there is a rebuttable presumption that joint custody is in the best interest of the child. What does that mean? That means the starting point in a custody case is we're going to start with the idea that joint custody is best for you guys. Okay? Well, joint custody is not appropriate in every case. I will tell you this. I mean, I've seen plenty of cases. I have cases right now where joint custody is not appropriate. So if it's not, that presumption can be overcome. That presumption can be rebutted. And we list how. If the court finds by clear and convincing evidence that joint custody is not in the best interest of the child. Now, one of the things that you'll hear the attorneys who get up here later, some of them, say is that the issue with that particular provision is that you've made the burden of proof required to overcome the presumption clear and convincing evidence. And so one of the things that you have to understand are the varying burdens of proof that we have in our court system, okay? And probably the three primary ones that we see are the preponderance of the evidence, okay? That's one. Clear and convincing evidence, which is what we state here, and then beyond a reasonable doubt. And so a preponderance of the evidence is this. It's 50% plus anything. It's if you have the scales right here and you can tip them ever so slightly, one direction or the other, you've met the burden of a preponderance of the evidence. And what we've said here by including clear and convincing as the standard to overcome that presumption is you're not going to be able to come into court with petty grievances anymore and deny a parent joint custody. You're going to have some real, legitimate reasons and solid proof that joint custody is not best, but you're not going to be able to come in anymore and say, well, when I talk to the other parent on the phone, I don't really like their tone. That's not going to get it. All the petty grievances that we have seen fill the courts in these family law cases over the years, and I promise you, I've seen them. Many of you probably have too. All the petty grievances that we have seen fill these courts, we're going to put an end to that. Because any judge, and I'm just going to say this, any judge worth their salt, if the burden is a preponderance of the evidence, can say, well, I find that the scales have been tipped ever so slightly in favor of one or the other, and I'm awarding custody to this one, and I'm awarding visitation to this one. No. It's going to have to be real evidence. It's going to have to be solid evidence. Now, one of the things that you'll hear the opponents of this say when they get up here is that clear and convincing evidence is such a high burden, it can never be overcome. They may even go as far to try to tell you that it's going to require expert witnesses in child custody cases. Wrong. Wrong. No, it will not. And let me tell you this. When I was a prosecutor in criminal court, the burden of proof in criminal court is beyond a reasonable doubt. And I had to meet that burden in every criminal case that I tried. It's the highest burden that we recognize in the law, beyond a reasonable doubt. And I proved countless criminal cases. I couldn't even tell you the number. I proved countless criminal cases beyond a reasonable doubt without an expert witness one. So don't tell me that you have to have an expert witness to meet the clear and convincing burden standard. No, you don't. If the evidence is clear, if the evidence is convincing, you can meet that burden, and judges are going to be able to make a record if that type of evidence is present. But I expect that you're going to hear those arguments from the attorneys that are here. So how do you overcome the burden? How do you overcome the presumption? Number one, if the court finds by clear and convincing evidence that joint custody is not in the best interest of the child. That's one. Two, if the parties have reached an agreement on all issues concerning custody, if the parties agree that joint custody is not best, okay, fine, that overcomes the presumption. Three, if one of the parties does not request sole, primary, or joint custody. Or four, if a rebuttable presumption described in subsection C or D of this section is established by the evidence. And so I want to clear that up, what that means. One of the objections that we've heard is that if we pass this rebuttable presumption of joint custody, there are already existing presumptions in the law, and that you would have competing presumptions. And so how do you deal with competing presumptions? Those presumptions are, number one, that it's not in the best interest of the child that the child be awarded custody, or that a parent or person seeking custody who is a sex offender be awarded custody. I think we would all agree with that. And that's an existing presumption in the law. And so what we say is if that presumption is established by the evidence, then that overcomes the rebuttable presumption of joint custody. And to prove that presumption, it's only a preponderance standard. So if you can just prove that ever so slightly, then joint custody, the rebuttable presumption of joint custody doesn't apply. The other one is the sex offender and the pattern of physical abuse. And so we have another existing presumption in the law that if a party to a custody action has evidenced a pattern of domestic violence, that it is not in the best interest of a child that that person receive custody. And so what we say is if that can be proven by even just a preponderance of the evidence, then the rebuttable presumption of joint custody does not apply. And then we add, and this was one of the things that the opponents of this bill suggested, and again, out of deference to them and trying to accommodate them, we added that the circuit court may enter an order to reduce areas of conflict in a manner determined appropriate by the court. So if you have parties that have issues with one another, the court can enter an order and be very specific to try to reduce the conflict that may exist between the parties. And those are the major things. I think that's probably the major things that the bill does. One of the things I will say, and one of the major concessions that, if you were familiar with the initial bill that was filed, the opposition, we initially had included that modifications, that the presumption of joint custody would apply in modification of custody actions, in other words, after the fact. And I would agree that that's not a good idea. When you have cases that have been through extensive litigation, through years in court, that have been settled by a court order, those are not the kind of cases that you should start with a rebuttable presumption of joint custody on. And so we took that out. And so if there's ever an action for modification, that doesn't apply, but it will apply in initial custody actions. Section 3, we talk about court shall consider the best interest of the child when making a child custody determination. That's existing law. A parent who is not granted sole, primary, or joint custody of his or her child is entitled to reasonable parenting time with the child, unless the court finds after a hearing that parenting time between the parent or child would seriously endanger the physical, mental, or emotional health of the child. If the party requests a written order, the court should issue a written order. And the court needs to be very specific as to the frequency, time, duration, condition, and method of what that parenting time is going to be. If you're not going to give a parent custody, then you need to be very clear about how much time they're going to get with the child. So that's all that says. And also in making that decision, the court should take into consideration the developmental age of the child. Section 4, after there's been a hearing of the merits on a child custody action, the court should enter a written order that includes facts, findings, and conclusions of law, and that maximizes the parenting time for each parent, and that's consistent with the best interest of the child. So the point is, if a parent is not awarded joint custody or obviously sole custody, then the court needs to try, to the extent that they can, to maximize time with that other parent, because, again, the research is clear. There is a mountain of it, that it's better for children to spend time with both parents and to have them actively involved in their life. And so I know I've said a lot. I don't want to belabor it anymore, but that's what the bill does. This is a good bill. It takes the next step forward from favored status to presumption status. We wouldn't be the first state to do this if we pass it. But I think it'll put us where we need to be, to put parents on an equal footing and to ensure that children have the benefit of two loving parents who want to be actively involved in their life. So with that, I'm happy to answer any questions, unless Senator Clark has.
As we finish here, I will come back to the other thing that will be said, is that the bill's not needed and goes too far. But I never could get an answer to where is the in-between? Because 2013 was obviously not enough. When we said that it would be favored, and in 2021, the judicial bench book said, even though the legislature said we favor joint custody, we don't. So obviously we had to go further by their own writings. And as we worked to work this out, I'd like to tell you that no one in the legislature, I think, works more at working out bills. We've got a water bill that I've worked on for 4 sessions that the Municipal League now endorses, as do the water providers. We've got an open child welfare courts, actually not open them, but we're allowing families and other affected members in. We worked with those judges. They now endorse that bill. It'll be in this committee. Education bill that I had the Department of Education and the governor completely rewrite. Civil asset forfeiture just reintroduced today with the version that the prosecutors actually rewrote. I have some skill at working with people and coming up with a compromise. There was nothing to be had. There was with the family attorneys outside Pulaski County across the state, but there wasn't with the judges and there wasn't with the Bar Association. And I like them both, so I hated that. But I know when people are trying to work with you, and I know when people are not trying to work with you. And so I hope you will keep that in mind when they tell you that we're going too far and that it's not needed. How far is far enough? And why did what we do before not do it? So with that, we'll be happy to take questions.
Representative Cloud.
Thank you, Madam Chair. Thank you, gentlemen. Representative Gazaway, help me understand as far as if one parent has more financial resources than the other, are they able to come in and use their resources then to persuade, if you will, the court that there is clear and convincing evidence? So I'm just concerned about how this fits in with if one parent has a whole lot more resources than the other. Thank you.
Sure, that's a great question, and that's something that we see in our courts already, even without this law. It's just it's a sad reality, but parents who have great wealth and large financial resources have the ability to come in and use that to their advantage in court cases. I think this bill would actually help with that, because unless they have, and that's why that clear and convincing standard is so important, unless they have, I don't care how much money you've got, unless you have a real, legitimate, clear and convincing reason why that child, or why joint custody is not in the best interest of the child, then you're not going to be able to destroy joint custody for the other parent. So it means they're not going to be able to take their resources and come into court and take every petty complaint that they can come up with and meet the burden in order to destroy joint custody for a child, which we know is best for the child. So I think this bill will actually help in that regard. I don't know that we can ever stop that. People that have the resources do that now. People that have the resources will continue to try to do that. But I think this bill helps with that clear and convincing standard, kind of build a firewall to stop them from being able to do it so easily.
Representative Barker.
Thank you, Madam Chair. You said that other states have already made this change to this language. Can you tell us a little more about that, like how many or any data on that?
I think we have some witnesses who can probably address that better than I can. I can tell you there's a presumption, I believe, in the state of Kentucky. There are presumptions, in other states. And again, I can't recall. One of the things that they've seen in Kentucky, I'll just give you an example. Also, I think Arizona But in Kentucky, I mean, I'm just reading from some of the information that you should have. Since they passed their presumption of joint custody, they've seen a 10% decrease in their family law caseload in 2 years. And, you know, that's the point. People that want to abuse the family law courts and try to use children as pawns because they can't get along, true joint custody law is very effective at preventing that sort of thing. Again, I know they have it in Kentucky. I think they have it in Arizona. I think there are other states. There are probably witnesses who can speak to that better than me. But we certainly would not be the first.
Thank you.
I'm seeing no other questions. Am I overlooking anyone? Representative Crawford.
Thank you, Madam Chair. And you may have said this, but this does not go retroactive, correct? We're going to start with, if this passes, we will start with whatever days in the bill. Is that correct?
That is correct. It's not retroactive. And then one of the important things that we did, it previously would have applied to modifications, which it would have allowed people to go back and open up their old cases and try to apply this standard. We specifically took that out. You know, that was an objection that was made that was well taken, and we took that out. We don't want to try to relitigate cases from the past, but going forward, this would be the new standard. So yes.
Follow up?
Yes.
Okay, I understand that. That's what I thought I heard. But what if a family wants to relitigate a case? I mean, is that still open or is it stopped? Where does this go?
We've not done anything to change the existing law. The existing law on modifications is if there's been a material change in circumstances since the last court order, then that provides a justification for modifying the last court order. If there's not been anything that's changed since the last time the court ruled, the courts won't allow a modification to go forward. But if you've got a material change in circumstances, you can bring a modification to try to change a previous court order, and this doesn't change that, so you'll still be able to do that.
One more follow-up?
I'll circle back around to you.
Okay, thank you.
Representative Berry.
Yeah, there we go. Thank you, Madam Chairman. So, Senator or Representative Gazaway, what is the biggest concern of the judges that you've spoken with? Because in relation to beyond a reasonable doubt or clear and convincing evidence, because to me it's almost like, you know, trying to get 90% of the legislature to agree on a certain issue. Can you address that for me? What is the biggest concern that y'all have heard from judges?
They do not want, or a great many of them, because as Representative Gazaway has pointed out, a lot of the younger judges do follow the law, thankfully. They want the discretion to do whatever they think is best, and whatever they think is best is not following the law that we start at joint custody.
Okay, I'm seeing no more questions. Representative Crawford, we'll come back to you.
Thank you, Madam Chair. Representative Gazaway, one of the things that we heard Representative Bott talk about today on the House floor concerns me. If a child, which nobody would know, but if a child is being abused and mom doesn't know it, dad doesn't know it, whichever direction it goes, will there ever be a time where the children will be talked to without both the parents there, that maybe that child, will there be a therapist there, I guess would be my question, other than just attorneys, to where that child would feel comfortable maybe opening up when they never have before?
That's a great question. I don't think that that's something that we specifically address in the bill, but I can just give you my experience. which is that a lot of times when a child has, if there's really serious allegations like that, and the parties know that that's going to be something that the court wants to hear about, I've had, there be a request that both parties leave the courtroom so that the child can talk to the judge by themselves, and that's something that I've seen routinely happen. Most parents and most parties in the litigation I've seen over the years will agree to that and step out of the courtroom and let the child speak their concerns to the judge. That's not specifically addressed in this bill, but that's just my experience in practice about how that's usually dealt with.
Follow up?
Yes, quickly.
Okay.
Let's try to stick to this bill.
I thought I was sticking to this bill.
Go
I
ahead.
apologize. My concern is that in joint custody, which I am for, my son's divorced, they're in joint, most days it works pretty good. So I'm not against that. My concern is a child, and I've seen that happen too, to where they have both parents leave the room and the child is talked to by a judge. Think about that. How a child would feel talking to a judge that they didn't know. So I'm coming from a part to where that child needs a therapist. I don't know where this goes, whether it's before all this happens, but if you're going to legislate dual parentship, then can we legislate therapy?
I think that's a good question. One of the things that I forgot to mention is that in a lot of these cases, it's pretty routine now that a judge will appoint what's called an attorney ad litem, and that attorney is there specifically to represent the child and the best interest of the child, and that is routine in a lot of these cases. Now, again, we just are trying to address joint custody in this bill, and again, that presumption of joint custody can be overcome. So it's not an absolute, this will not be an absolute law that every case has to be joint custody, not at all. It just simply resets the starting point to say, we're going to start at joint custody, and if you can show me a good reason why it shouldn't be, then the judge has the discretion not to order it. But in many of these cases, judges appoint attorney ad litems to represent the best interest of the children, and they meet with the children privately. They make a report to the court about their findings. And so that's how the courts currently kind of address that, but therapy it can always be helpful in those situations too.
And Representative Crawford, that's a good question. My experience, and I'm not an attorney, but my experience is mostly in dependency and neglect, where the children are assigned an ad litem. They can be in these cases, but where they are assigned an ad litem, which is an attorney who represents them. And they can ask the courts for whatever they think is best for the children. And often in those cases, there are counselors, therapists, etc. And that it really is the state's avenue is that if someone suspects abuse or neglect, you can call the hotline, and then DCFS, unless they think it's criminal, and then CACD would do an investigation, and then you would set off a whole nother chain of events if they found a true finding, in which case it's not unusual to have other type people involved with the children.
That completes all of the questions from committee members. We're going to move to the audience. Representative Bentley.
Thank you, Chairman. In order for us to be able to hear everybody that came here to testify, I'd like to limit it to 4 minutes per speaker per side. So each speaker would have 4 minutes to share with us.
Okay, that's a proper motion. The motion, let me repeat that, is we're asking each speaker to have 4 minutes. You're asking each speaker to have 4 minutes, correct?
Yes.
Representative Bentley. We do have a very long list, so that's non-debatable. All in favor, say aye.
Aye.
Opposed, say no. Okay, that passes. So we will move now. Representative McClure, I'm seeing your name here after Representative Bentley's motion. Did you? Oh, Okay, let's very quickly.
Representative Gasway, I do have a question for you. Can you give us just a quick estimate? If you take out in joint custody, the parties that have reached an agreement or the parties where one is not requesting sole or primary custody, how many is left? What percentages I know that's not exact, but just a ballpark. Are we talking about 20% is looking at joint custody is what they're trying for, or is 70% of it's already settled before it gets to the court?
Boy, I don't know that I can answer that accurately. As far as a percentage goes, I will tell you, again, my experience is that you're seeing a lot more parents, it seems to me, agree on joint custody these days. When people come to me in my office over these matters, I don't do this exclusively, but I do enough of it to know, I'm hearing more from people that they want joint custody and that they're willing to settle for joint custody. I think you see a lot of those cases settled, where both parties want joint custody, and there's certainly nothing that would prohibit that. But, to try to put a percentage on the number of folks who are contesting custody these days, I think it's probably went down. I don't know that we have as many contested custody cases as we once did, because I think there's kind of become this public awareness that joint custody is best for kids, and it's best for kids if parents who are divorced, even if you don't like one another, get along for your child, because if you don't get along, you're really going to affect your child. So I just think we'll see a lot more of that settle outside of court, but I can't quantify it, and I'm sorry.
Thank you.
Okay, we're going to move now to the audience. We have a lot of people signed up to speak for, and we have several signed up to speak against. So I would ask you, we want everyone to have their say, but I would ask you please to keep your remarks as brief as possible. And if someone has already made the point that you're making, you might want to consider just making a different point in that case. So first we have against Angela Mann. Is Ms. Mann here?
Madam Chair, do we stay here or leave?
If you'll go ahead and I'm sorry, move out to the audience.
Okay, thank you, Madam Chair.
Ms. Mann, if you would identify yourself for the committee, please, when you reach the table. Yes. And push the button. You may need to pull it towards you.
Okay. My name is Angela Mann. I am a family law attorney, and I am here on behalf of the Bar Association. First, want to say that we have attempted to work with Senator Clark on this bill, and we have actually suggested some amendments, and those amendments have not been accepted. I'm going to talk just on a couple of issues, and I think some of you have already asked questions about these issues, so please ask if you have anything to follow up. First, I want to talk about the clear and convincing evidence standard. The clear and convincing evidence standard was set by the United States Supreme Court to protect certain constitutional rights. The United States Supreme Court defines clear and convincing evidence as substantially more likely to be true than untrue, and the court must be convinced that the contention is highly probable. Black's Law Dictionary defines clear and convincing evidence as highly probable or reasonably certain. This is much higher than this typical burden of proof in family law cases, which is the preponderance of the evidence. Clear and convincing evidence only appears in Arkansas courts in a few areas. It shows up with termination of parental rights, adoptions, and then in the employment context. As Representative Gasaway mentioned, in the custody statute, there is a presumption already that it is not in the best interest for children to be placed in the custody of an abusive parent or a parent who is a sex offender. But that burden must only be proven or disproven by preponderance of the evidence. So there's a disconnect. You only have to prove abuse or a sex offender status by preponderance of the evidence, but we have to prove, for custody purposes, a clear and convincing evidence, and those two don't mesh. This standard is just too high. In many divorce cases, we do have to have experts, and I believe in the handouts that y'all were provided a few days ago, there's a statement in there that clear and convincing evidence does not require expert testimony. And in my practice, I have to have expert testimony in a lot of divorce cases anyways. Experts include the child psychologist. Sometimes we have a custody evaluation. Sometimes we have to have a therapist. Those are all experts, and many litigants can't even afford for those people to come to court. They charge more than the attorneys in many cases. And a lot of people in domestic relations courts don't have resources. And I believe it was asked if one party would have the ability to use their resources to meet clear and convincing evidence, whereas the other party would not be able to do the same. And I think that's a real risk with this bill. People who want to litigate are going to litigate regardless of what the law is. And people with more resources can afford to bring experts to court. They can afford to do more to present the evidence that the court wants to hear to meet the clear and convincing evidence standard. Most custody cases are decided by, right now they're decided by a preponderance of the evidence. And that burden is often hard to prove. It's hard to meet. Courts they essentially have three options: joint custody, custody to mom, and custody to dad. And those three options are being taken away to an extent by assuming that both parents are fit, willing, and able, and even want joint custody, because the presumption assumes that joint custody is in the best interest of the children regardless of any of those factors being present before anybody steps into court. So, and Ms. Hoover is going to talk about the presumption a little bit more, so I'm not going to go into that too much. But to overcome that presumption by clear and convincing evidence is too high a bar to reach. Senator Clark and Representative Gazaway, I believe, cited to two states' statutes that they have based their statute
Your
off.
time is up. Were there questions for this witness? Representative Hudson.
Thank you, Madam Chair. I'm glad you finished on those two states because that was one of the questions I had written down. If we're talking about basing this new statute on something that's already been done, are there significant differences in what this statute does, and have these statutes been successful in other states?
The two statutes that are referenced are Kentucky and Arizona. The Kentucky statute does have a presumption that joint custody is in the best interest of children, but the burden of proof in that one is preponderance of the evidence. And that statute went into effect in 2018. The pamphlet, I believe, that y'all were given shows that there was a decrease in family law cases in Kentucky, but I'm not sure if those were tied. It's unclear whether those were tied to the custody statute or if that was just a general decrease. The Arizona statute does not have a presumption of joint custody. The Arizona statute actually says, it actually says that there's a presumption that the parents should share in decision making and maximize parenting time, and the statute specifically says that this does not mean there's a presumption for equal parenting time. And that statute has been found in the Fabricius study that's that the proponents of this bill will cite to, says that the Arizona statute is a model statute, and it's actually very similar to ours.
Follow up, Madam Chair?
Yes.
So you've mentioned the preponderance of evidence standard a couple of times as opposed to the clear and convincing. Was preponderance one of the things that the bar would prefer in this type of statute? Is that a more realistic burden?
It is a more realistic burden, but we would actually prefer that there not be a presumption at all, and that the focus remain on the best interest of the children. Our proposal was to codify the existing case law, which essentially states that joint custody is the starting point. And I believe that's what Representative Gazaway stated, is that they want joint custody to be the starting point and not just favored. And we agree with that.
Representative Berry.
Thank you, Madam Chairman. So I want to wrap my head around this. So correct me if I'm wrong, but did you say that a judge has three choices: the mother, the father, or joint custody. Correct?
Yes.
Okay. But you also said that whether the parents like those choices or not. So essentially, a judge could mandate joint custody whether the parents wanted it or not.
That's correct, and I've had several cases where judges have done just that.
Okay. Thank you.
Thank you. Thank you for your testimony.
Thank you.
Next, we have, and if I mess up on these names, when you come forward, please correct for the record. Gary Crumpton, speaking for the bill. I think it's Greg, sorry. And please introduce yourself.
It is Greg. I'm Greg Crumpton. I'm a family law practitioner in Lonoke County, Arkansas. I've done it for 14 years. A parent of an 11, 13, and 15-year-old I've had joint custody equal time of since they were 2, 3, and 5. Mr. Gazaway, Representative Gazaway did a very good job explaining legally what the bill means. I'm going to take my time to explain how I feel like it is beneficial to the best interests of children and how it will be applied. As Senator Clark and Representative Gazaway stated, this bill requires for a judge to vary from joint custody that there be clear and convincing evidence to show otherwise. What I believe that this does is this will lead to more joint custody decisions, not because the same amount or more people litigate these cases and judges make more joint custody determinations, but because if these individuals have good counsel, they will understand that it is in their best interest of their children to settle if that's what's going to be found. I think that joint custody is completely dependent on an ability to co-parent. And in my experience, when these people come into court and they spend a year saying the ugliest things they can think of about each other, to a judge, and to their family, it makes co-parenting an impossibility or greatly hinders it on the back end. We need people to be able to communicate about appointments, to be able to communicate about the needs of their children, to stick up for each other. We want parents to do that. So I believe in practicality, the initial child custody determination will lead to less litigation and more decisions that are joint by agreement, which will allow people to come out and co-parent better on the back end. Now, I would not have been in favor of this legislation had it not been amended, because as amended, now we're on a preponderance standard. So these parents come out at joint by agreement. Hopefully that works better. What they can do at that point in time is, if one party is not pulling their weight, they're not making a doctor's appointment, they're tardies. Most importantly, one of those parents is not co-parenting with the other parent. Then at that point in time, those same parties can go back in, and with a lower preponderance standard, a judge can undo a joint custody arrangement. I think it will lead to more settlement on the front end. I find that the cases that settle don't come back to my office. Those people co-parent together, they raise good kids, those kids become good citizens, and those good kids raise good kids. And so for that reason, I'm in support of this bill. If there's any questions, I'm happy to field them at this time.
Okay, committee, any questions for this witness? Seeing none, thank you for your testimony.
Thank you.
Next, we have Haley Smith speaking against.
My name is Haley Smith. I am a family law attorney from Jonesboro, Arkansas. I practice almost, in fact, I would say completely exclusively family law. I am also a certified attorney ad litem. This was mentioned earlier. This means that I've received additional training, gone through additional continuing legal education courses to be able to represent children in these highly contested cases. One of the questions earlier was asked is, what do children do when there might be abuse in the home and they don't want to say it in front of lawyers, they don't want to say it in front of judges, or they don't want to say it in front of their parents. Let's put them in a room with the judge and have the judge ask them. Children very rarely disclose those kind of things to their own attorneys. I'm a small female. I am not an intimidating physical figure. And children are still fearful to tell me things, to tell on mom and dad. And even still, ad litem's can be considered a luxury that some can't afford. There was a question also about the cost of these litigations and how this bill will introduce the idea that there isn't a financial advantage. Vehemently disagree, because those who want to litigate are going to litigate. Those who want to litigate and have the means to litigate are going to drive up attorney's fees by doing things like depositions, subpoenaing witnesses, expert witnesses. Attorney ad litems cost money. We are given a certain amount of AOC funds to cover up to $1,250. That's approximately 10 hours, a little more, 11, 12 hours worth of time. But a good ad litem is going to go to everybody's home, is going to talk to school teachers, going to talk to the child multiple times to build the rapport that's necessary for children to be able to confide in you. You're going to run over that, and a lot of counties don't have the ability to make up the difference when the AOC funds don't cover the ad litem. So the ad litem can't do their job. The ad litem can't dig in as much. The same is true for family attorneys. You don't have the funds available to do the digging, to call the experts that you would need to overcome this clear and convincing standard. And is my recommendation as an attorney ad litem going to constitute clear and convincing evidence? Does it meet that burden? There's nothing in here that says it does or it does not. But as an attorney ad litem, the judge on the case does not have to follow my recommendation. So since they do not have to follow my recommendation, does that stand to reason that it does not constitute clear and convincing evidence that would overcome this presumption? The burden is too high. It will lead to increased litigation costs due to the expense of ad litems and experts. And that is why I am not in favor of this bill, and I urge you not to vote for it.
Any questions for this witness? Seeing none, thank you for your testimony. Next, we have speaking for the bill, and I'm probably going to mess up your name, Elizabeth Ruggiero.
I always know it's me because nobody can say that. My name is Elizabeth Ruggiero. I am a PhD marriage and family therapist. I've been a clinical supervisor for probably way too long. I have been working with families since 2001. I'm going to go off script. I had a beautiful thing written, but everybody's already said it. So what I'd like to do is actually just kind of enlighten you as what happens when these children and everybody else is talking about come to a clinician. We see less fighting, interrogating, and abuse when it's a shared joint custody. When you level the playing field and both parents know that they have a shot at working with these kids, there's less controversy. We have a level playing field. There's a threshold that we can start with. So instead of us as clinicians sitting there having to take 2 or 3 or 4 or 10 sessions working with these people to get through the fact that something's not fair or that a judge didn't listen to them or that they love their children. And I'm going to be pretty blunt. Everybody so far sitting up here said the parents, the parents, the parents. I'm going to say it. Fathers. I'm seeing way too many fathers that do not have contact with their children. And that is what's wrong right now with everything. I'll say it. It's what's wrong. I need more fathers putting their hands beautifully on children. I need them throwing footballs, and I need them spending their time with their children. And when I have to fight with a system, the other reason that you won't hear too many clinicians sit up here is because we're scared. When I called my colleagues and I said, do you want to come sit with me? They said no. When I call my colleagues and I ask them, how much time do you spend in court? They say none. We are afraid to go to court. It costs double to get me into court than it does a lawyer because I am sick and tired of being beat up. Because instead of me going in there and being able to say, yes, Your Honor, judges, everybody, they need two parents. All the evidence that's sitting in front of you that everybody else is going to stand up here that I have this eloquent speech written to say, we need both parents, we need both parents, we need both parents. I spend all my time and money and energy doing that. We know this. You know this. What also happens, and I want to be really clear about, is this is what happens in therapy. Has any of you ever done a group project? Because you should have some trauma if you went to school and had to do a group project. Now, if you had to do a group project and you went into it knowing that you were the kid that was going to carry it all, and that you had the two athletes that weren't going to do anything per se, you already go into the group project not wanting to do it because you're going to do all the work. Now I'm speaking on behalf of a lot of mothers. I was a single mother. I had to raise my children alone. I would have done anything to beg for my husband to come in and help me. He didn't. That's me. I was also raised by a father. That's me. But I see day in and day out, we don't have enough of both parents in these situations. My job would be easier. My clinicians would go to court more often. We'd have a level playing field, and we would be able to talk to the kids about their problems and the parents about how they're not co-parenting together instead of this unequitable, unfair, unjust way that it's being done now. I have too many fathers that do not have access to their children, and it's still happening. And it'll happen when I walk out of here, and it'll happen tomorrow, and it'll happen next week. It happens way too often, and you will not hear that from enough clinicians. It won't happen because we're too scared to sit here. We're too scared to go to court. We're scared because it goes against us to say what it is that I'm saying. That's it. Any questions?
Thank you. Any questions for this witness? Okay, seeing none, thank you for your testimony. Next, we have speaking against Lauren Hoover.
Madam Chair, I do have handouts for the committee, and I would ask that they be distributed.
Would you bring them up here, please?
Absolutely. And Madam Chair, if I could impose, may I have a copy of the amendment? Does anyone have?
We really need you to give your testimony now.
Absolutely. Everyone, my name is Lauren Hoover. You've seen me testify on January 27th. I'm here today because I've been working very hard with the proponents of this bill. Thank you very much. This is the first time I've seen a copy of this amendment. Senator Clark on February 4th made promises to the Senate floor that he would work with the bar to come up with a compromise. Now, Senator Clark has acted in good faith. And at this moment, however, we did not receive a copy of this amendment until I walked in the door and had to receive it from one of the members of your committee. I met with Senator Clark and other members on sent suggestions on February 2nd, 2021, spent an hour on the phone and in Zoom on February 3rd, sent emails to Senator Clark on February 8th. I had a 2-hour meeting in person with Senator Ricky Hill and Senator Clark. I spent 90 minutes on the phone or in another Zoom with Judge Singleton and Dr. Fraley and Senator Clark. I've spent an hour on the phone with Representative Gazaway. And for them to get up here and say, respectfully, that we just said no, you will see in your handouts that I have placed before you that there is an Exhibit E, and it is the proposed suggestions. I understand I don't have a vote. I am not an elected member, but it is the proposed suggestions of how we can improve the current bill to do what the concerns are of the proponents without endangering the best interest of the child. In your handout, on Monday, there were some statements made by another member that said that I didn't know what I was talking about when it came to the law, so I'm not here to ask you guys to take my word for it, so I brought you the law. So attached in Exhibit A is the Arkansas Supreme Court case on what a presumption is. And a presumption is a legal inference or an assumption that a fact exists based on known or proven existence of some other group of facts. So before we've sworn anyone in, a judge is going to be required to think that both parents are fit and proper to have joint custody. In the handouts provided by the proponents, they did polling. And if you'll notice in the polling, one of the questions says, how beneficial, if at all, is it for a child to have significant time with each parent, assuming both parents are fit, willing to be parents, and live within a reasonable distance of each other? Not surprisingly, 80% found that to be extremely beneficial. That's with 3 assumptions. This bill is asking for the court to make those assumptions about the litigants that come into their courtroom. And then instead of having the court swear everybody in, start everybody on equal footing, which we'll notice in the suggested language in Exhibit E, we use the Kentucky statute that would say, okay, because Senator Clark kept saying, what does favored mean? What does favored mean? And I said, well, it means this. It means both parents are here on equal footing. Well, it doesn't say that. Well, let's make it say that. Everybody understands what that means. Representative Clure, you asked about financial resources. Let me tell you why this is going to be bad. If you have the financial resources, or you know you don't have the financial resources, you know that whether or not it's in the best interest of your child that joint custody should be awarded for your child based on a number of scenarios, you don't have the money to fight that, so you just have to agree to that. I don't care about parent 1 or parent 2 in that case, but that's going to be bad for the kid. You can tell by the handouts that you have before you that were provided by the proponents, that's a pretty expensive handout. Everybody here that's speaking for the bill, they have active litigation or they were recently in case. That thing costs money. I used my copy machine at my office and 2 stacks of paper. My clients can't afford those handouts. They can't afford the experts. You don't need experts in a criminal case to do elements of a crime because they're factual. Did the defendant enter into the building? Did the defendant cause damage? That doesn't require an expert. That's in the ordinary comprehension of a layperson who is sitting in the jury stand. Everything in domestic court is about feelings, about understanding. It's a he said, she said. It's about, is someone trying to alienate, is something, etc. Last thing. In March of 2020, the Arkansas Supreme Court made a very strong case in Pace v. Pace. You all have heard me talk about this case before back on January 27th. Please refer to the cases in the handout. This is already the law.
Were there questions for this witness? Seeing none, thank you for your testimony.
Thank you very much.
Next, we have Brian Vandiver to speak for.
Thank you, Chair, members of the committee, for the opportunity. I speak in support of this good bill. I ask you to vote for it. My name is Brian Vandiver. I'm an attorney. I've been practicing for 20 years in this area. And the reason I'm here today, I am a father of 3 children. And I'm advocating not for myself, but for parents, moms and dads in the future that come through our system because I've seen it. I've experienced it. And it's a system where if the preponderance of the evidence, a feather of evidence falls one way or the other, that's the difference between being a custodial parent or being a visitor relegated to every other weekend. And a lot of them have said presumption of clear and convincing evidence is too high. But it's not too high, it's appropriately high. These cases are important. They're deciding fundamental rights between children and their parents. These are not car wreck cases. These are cases that will impact people's lives forever. And so we should start where the parents share equal custody. If both parents are fit parents, our policy as a state should require clear and convincing evidence why joint custody and equal time with each parent is not proper. Period. Full stop. This is consistent with protecting the rights of the children and the parents, and it also will reduce litigation. Contrary to what you've heard, the studies from Kentucky and Arizona clearly show that litigation is reduced when you have a presumption of joint custody. Now, I'll give you some other examples because I am an attorney and I know the law, and we all share the same degree. I don't practice family law, but I practice law. I could take divorce cases tomorrow if I wanted to. I choose not to. But I understand the clear and convincing burden of proof, and it's elsewhere in our law where important interests are in stake. For example, defamation against a public figure, like elected representatives. If you want to prove defamation against the newspaper or someone in the public, you have to prove that by clear and convincing evidence. Why? Because that protects the free speech rights of the public. If we want to, in Arkansas, award punitive damages against a corporation, you have to prove that by clear and convincing evidence. Why? We protect corporations and other tort defendants from punitive damages. If parties to a contract or a will want to change the terms of the written agreement, you have to do that with clear and convincing evidence that that was not the intent of the parties. Why? Because we protect the parties in that agreement. Are these types of cases less important than those? I think not. Child custody cases are some of the most important cases in our system. Why should we let a feather of evidence tip the scales one way or the other that impacts the lives of children and parents forever? We shouldn't. That's why this burden is so important. It's why it's so crucial, and it's why you hear a lot of family law attorneys argue against it, because they know it will reduce litigation. And that's the point of it. To reduce litigation, to lessen the conflict, to take families who are throwing these petty grievances against each other out of the court system, encourage them to settle, because if they know going into the litigation, if any attorney knows the law has changed, they will tell that parent, you shouldn't fight about this because you don't have really a chance with these petty grievances. You need real evidence to change custody. Finally, this bill is about equality. It's about parental equality. It's about gender equality. If you believe in equality, how can you vote against this bill? Because we know the stats show that 80% of
Your
sold
time
custody.
is concluded.
I appreciate you very much. I ask you to support this bill.
Any questions for this witness?
I'd be happy to answer any questions.
Seeing none, thank you for your testimony.
Thank you, Chair.
Next, we have Michelle Huff speaking against. Please introduce yourself.
Pardon me?
Please introduce yourself.
Okay. Good afternoon. My name is Michelle Huff. I am a circuit judge in the 3rd Judicial District. I've been a circuit judge now for a little over 2 years. I practiced law for 25 years prior to becoming judge, and I did practice in the area of domestic relations, and that is primarily what I handle now. I'm here on behalf of the Arkansas Judicial Council and on behalf of myself to oppose this bill. Everyone's already talked about the standard. I want to talk to you about practical points, and I want to tell you what I do. Now, I'm a not brand new, but I'm a new judge, and I can tell you that this is currently the law. I don't see any reason to change it. When people walk into my courtroom and it's a contested custody case, I always ask them, the law says that joint custody is favored in Arkansas. Why shouldn't I grant joint custody here? And usually I will get the parties live 150 miles apart. They live in separate school districts, or they'll tell me I'll hear it later and we'll get into it. When I have a temporary case, when the parties live in the same school district, almost every time I will grant temporary joint custody. Then I get to see how they're getting along when we get to the final. That is the law. So it's hard for me to imagine that judges are just ignoring that. If you have a case with where you have 2 good involved parents, that's what you're going to do if it's at all possible. But one thing that I always asked in my practice before when someone came in and wanted it is, why do you want it? Because the devil's always in the details. Is it that you want more time? Sometimes it wasn't really about time. The person wanted to not pay child support. And we spent a lot of effort and a lot of time creating the new Administrative Order 10, which is fabulous. It takes into account both parents' incomes. But it says that if both parents have 147 nights or more, then the child support goes down. And I am terribly worried about the disparate impact on low-wage earners, and which is primarily a lot of times going to be women, and the impact it's going to have on the children. Control. Control, sometimes it's not really about time with the children. It's about control. Believe it or not, I've seen cases where it's my week and it's prom and you can't come over and take pictures. It's my week and I'm going to do this and you can't come. The problem is we're going to be doing this in the initial determination, and I would argue that it's going to create more litigation, because then when they can't get along, then they're going to have to come back. I want ADHD medicine in my week. Well, I don't. So there's a huge can of worms. Paternity. I've got a brand new 6-week-old baby born to a 19-year-old mother and a 20-year-old father that are not married. Joint custody. Joint custody is the presumption, so paternal grandma and dad want to have that kid every other week. I mean, I've got them fussing now, not wanting to go because they're breastfeeding. Sorry, honey, daddy's going to visit that kid. Get a breast pump. That's just the way it is. And I know the first 6 cases I had, I ruled in favor of the father. And I got worried that that was going to be a problem. But I can't look at everything. I have to look at what's in front of me. That's what we get paid to do. Judge is judge. When I went to Reno, a couple of years ago, we were given a book. You are no longer a lawyer, you are a judge. And one thing really hit me in that book. This retired judge said, if you handle domestic relations cases, remember, don't split the baby. It's not fair to the baby. And that is the only thing that matters. I cannot tell you how many times I've heard from a parent, but it's not fair. It's not fair. I'm supposed to get 50%. It's about getting 50%, not about what's best for the child. Do you want to go every other week and pack up and go to somebody else's house and stay that week and come back, or every 2 days, every 3 days? Some kids do, and if they're teenagers, that's different. If it's a 2-year-old and a 4-year-old, they need more structure. But if you put this in place, that's what we're going to be bound with, even in paternity. And remember, sometimes we've got cases where people have never been married and they've been separated for 5 years, and then it comes to court.
Your time is completed.
Okay.
Thank you. Thank you for your kind remarks about the child support charts. I was on the committee that worked on that.
Right. It's wonderful. Thank you.
All right. Next, we have speaking for the bill, Patrick Fraley.
Thank you, Madam Chair. Thank you, Madam Chair, members of the committee. My name is Patrick Fraley. I'm an ENT doctor in Conway, Arkansas, and a founder of Arkansas Advocates for Parental Equality. I've been a non-custodial parent for over 13 years, and my son is almost 16. So the outcome of this bill isn't going to change anything for me or my family, but it will change things for the people who contact my organization for help on a regular basis, and there's many out there. So I'm going to answer some of the questions that a lot of you have had. There are several states, currently this year, there are a lot of states that are trying to get a presumption of joint custody because this is something that's sweeping the nation for good reason. This is Missouri, New Mexico, Iowa, North Carolina, among others. Texas actually has a bill right now to overturn their long outdated presumption of every other weekend custody. I want that to sink in. In Texas, they still have a presumption you should have your child every other weekend. And even though, I mean, that seems foreign to us, but there's actually, their family law lobbying group is continuing to oppose that bill. As of now, there are 2 states with presumptions of joint custody. As someone mentioned, that is Arizona and Kentucky. Arizona's did come with a case law, or it came with their law in 2013 that required maximizing parenting time with each parent. The difference is their courts interpreted that to be a presumption, and that's been clear in the law ever since. As opposed to when we said favored, our courts came back and said, but it's not favored. So that's the difference. That's why that law isn't exactly applicable here if we can't model after theirs. The other states, Kentucky, they passed a presumption for temporary orders in 2017, and then because that was successful and popular, they did one for permanent orders in 2018. And I do want to point out that these actually apply to modifications as well. So in some ways, these went further than our bill. In each case, there was opposition saying how just disastrous the outcome of those bills would be. But the thing is, the disaster never happened. Instead, other states are citing them as positive examples and want to follow. In 2018, there was a legal journal, that published a study on what their legal professionals thought of their presumption in Arizona. And overall, they thought of it as positive in best interest of the child, and they did not see any increase in litigation. So again, no increase in litigation when they've actually had it in law. And then in Kentucky, public opinion surveys have been positive towards it, and then, as mentioned, their Office of the Court saw their domestic cases fall in 5% of each of the years following implementation of the law. Some mention has been made of the public opinion poll. I want to point out that this is a weighted public opinion poll done properly by official polling groups. 87% supported a presumption of joint custody. So that's a very high number. It's hard to get anybody to agree on anything nowadays, but 87% support a presumption of joint custody. Another finding was that 78% felt that awarding custody to one parent over the other increased conflict between parents. So for years, we heard judges and attorneys argue for primary custody as a solution to parental conflict. The thing is, sole custody awards are part of the problem, not part of a solution. Some mention's also been made of this best interest standard. This came out after the maternal preference was given up and replaced it. On paper, it appeared flexible, child-focused, and gender-neutral, but in practice, it is not without its critics. It's credited with creating the high-conflict, money-driven industry of family courts that we know today. It's been too flexible to produce predictable results, so if there's no objective basis to predict a custody outcome, it leads to prolonged and contentious litigation. That's detrimental to children. When you have no objective basis and to decide between two fit parents, then you start inviting biases about gender, parenting styles, and cultural values to make over your decisions. This excessive discretion put judges in a position they were never intended to be in. The presumption of joint custody restores a degree of predictability and provides a backdrop of equality, a starting point of equality for both parties to negotiate under.
Your time is completed.
Okay.
Any questions for this witness? Seeing none, thank you for your testimony.
Thank you.
We have W. Lance Owens speaking against the bill. Is Mr. Owens in the audience? Okay, not seeing him. We have Kathy Compton speaking against the bill.
Thank you, Madam Chair, committee. I'm Kathy Compton.
Please turn on your mic and pull it towards you a little bit.
It's red.
There you go. You got it.
I'm Kathy Compton. I'm a circuit judge for Pulaski and Perry counties. Just completed a 6-year term doing probate and domestic work. I'm now doing all criminal. But I had a lot of interest in this bill because Representative Gasaway, when I started practicing law in the piney woods of South Arkansas, we still had the tender years doctrine. So I know all about that. But I've been sitting here listening, and as I read the bill, I don't understand what problem we're trying to fix that's not already been fixed. As a circuit judge, I started with the statutory presumption that joint custody was what we were going to do if we could. I believe very firmly in joint custody. I've read the studies. I know the statistics. Children do far better. But I did that throughout my term as a domestic relations judge. I started with the presumption that you all have told me I start with, that joint custody should be what we do. And then, starting with that, we go into what's in the best interest of the child. Why is it in the best interest of the child? So I've been sitting here the whole afternoon that we've been talking about this, wondering what problem is it we're trying to fix? Because I already did all of that. Judge Huff already did all of that. All of my colleagues already do all the things that you're asking for. Now, I do think that we've seen attrition taking care of part of this problem. Older judges, they were chancery judges then, older judges, primarily male, primarily white, grew up in a generation in which they didn't believe that they should have joint custody. They didn't believe in that. They thought the woman was the one who stayed home. They carried the tender years doctrine well past its actual law, the time that it was the law. But attrition has taken care of the bulk of that problem. You all know that we have to retire when we're 70 or we give up all of our retirement. So that also has taken care of a large part of the problem. We have judges now who believe in joint custody and who start with joint custody as their presumption. So I think this is a problem that somebody has created in their head because maybe they didn't like the outcome in their case, because this is what we do every day. And I didn't use up all my time, but I'm here for questions if anybody has any.
Representative Hudson.
Thank you, Madam Chair, and thank you, Your Honor. Real quick, because you said it a couple of times that...
Representative Hudson, would you press your mic again? There we go.
Okay, here we go. Thank you, Your Honor, for being here. So you've mentioned a couple of times that this is more or less what the bench is already doing. So why would you say that this new bill would be bad?
Well, everybody's already talked about the burden of proof. I think the presumption, the clear and convincing evidence is primarily used for constitutional issues, and it's a very high burden, as both the Arkansas Supreme Court and the United States Supreme Court have told us repeatedly. So I don't think we need to get into that. I also echo what some others have said. This is a bill asking for inequality because of the money it's going to take some litigants to overcome that burden or any burden. There's a I don't have the bill up here with me, but there's a provision in there for if I didn't, I keep forgetting I'm not doing this anymore. If I didn't give joint custody, I'm supposed to say all these factors about the child's mental health and emotional health and physical health. I'm not a doctor. I'm not a therapist. I have a lot of training in the law. I don't have training in medicine or mental health. That's not what I'm looking for. I look at all the things that tell me what is in the best interest of the children. Because even back in the dark ages, when we did operate under the tender years doctrine, even then, it was still the rule that we looked for what was in the best interest of the children. That's what we do.
Follow up, Madam Chair?
Yes.
And thank you for that, because I was thinking about that as you testified. And I don't know if you've had the benefit of looking at this amendment or not, but since we do have a judge up here, I wanted to ask you about something. In Section 1 of the original bill, it says that this will apply to an action for divorce or an action to modify a custody order. Now, in the new amended Section 1, it says it will be in a divorce or a paternity matter. To me, I have some concerns about a paternity matter because in my understanding, the character of that type of proceeding is much different. And I wondered if you could talk a little bit about that.
I'm glad you asked that question. The character is way different. And, for one thing, the Arkansas law as it stands right now says that a single mother is the parent until there's been a proof of paternity. So a lot of times we have people coming into court seeking joint custody, and they hadn't even been declared the actual father yet. There'd been no DNA test. There'd been nothing. They'd say, well, my name is on the birth certificate. Okay. But so in paternity cases, I think this would be a real disaster. And I hate to say something that's as indelicate as this, but what we see often in paternity cases are very young people who barely know one another. And that's just the nature of the beast. Teenagers will be teenagers. What can I say? I think it would be a disaster for paternity cases.
Okay, seeing no more questions, thank you for your testimony.
Thank you.
Next, speaking for the bill, Stephen Bright. Please introduce yourself.
Thank you, Madam Chair, Mr. Vice Chair, members of the committee. I'm Stephen Bright. I have a unique perspective in all of this. I'm one of the few testifying today that sat in your position. I was a member of this body for 6 years, from 2000 to 2006. Back in 2003, I got a call from a constituent, and they asked if they could come to the Capitol, and they met with staff. And it was a minority couple in my district, and they were young, been married about 10 years. He had been divorced, had a 7-year-old child. I walked into the side office, and they had a stack of papers. It was about 1.5 feet thick. And they started telling me all of the tragedies of their court case and how he had been through so much court, and he was seeing his daughter one day a week and every other weekend if he was lucky. If he made his ex-wife mad, she would withhold custody or visitation. And his wife was telling me what an amazing husband and father he was. And I walked out of that meeting that day and saying it couldn't be that bad. 1.5 feet or 1.5 feet stack. It couldn't be that bad. I'd not heard anything about this. I seemed to be a pretty informed legislator. I met with him several more times, and I just could not wrap my head around it. I was on the Judiciary Committee at the time, so I asked members of that committee, I asked members of the bar, I asked members of AOC, is it this bad? They said, absolutely not. This was in 2003. Back in 2003, we passed a law that says you may consider joint custody. It's been 20 years, guys. I go back to that couple. I told them over and over, I didn't think that I could do anything for them. And what they were asking me to pass back then was just to give him the right to love his children, to be the dad that he promised them that he could be. They walked out of my meetings more dejected, more hurt than anything. Shame on me. When I asked the members of the committee and the AOC and the Bar Association if this bad, they said, no, it's not that bad. Shame on them. Because 5 years later, I sat in the same exact position as that young couple. I was going through a contentious divorce, all sorts of accusations. Very good fodder for the front page. I realized then it's not that bad. It's a hell of a lot worse. Judge Moody just said she doesn't know why we're here. And I'm going to tell you something about Judge Moody. She was my judge. And she is one fine judge. And I told her this 2 weeks ago. I don't even know if she remembers running into me at lunch. Miss Compton, I'm so sorry. And she took notes. She did everything that she could to make sure that the best interest of my children were taking place. My first judge, I've been divorced twice. I was a bad husband, but a good father. I ask for your support of this amendment, or in this bill. Thank you so much for your time.
Any questions for this witness? Seeing none, thank you for your testimony.
I apologize to Judge Collins.
That concludes all of our speaking. We don't have anybody else signed up speaking against, so the rest of the witnesses are speaking for. Matthew Engel.
Good afternoon, Madam Chair and members of the committee. My name is Matthew Engel, and I'm here today as a non-custodial parent. I'm not an expert. I'm just a father who wants the opportunity to be a dad more than every other weekend. I have a son and 2 daughters. My son was born while I was in the middle of a 5-year enlistment in the United States Marine Corps. After I returned home in 2011, I went to court to establish paternity. Joint custody wasn't favored at the time, so I ended up with visitation just every other weekend. I'm currently employed as a police officer, and I'll be graduating law school in May. The reason I went to law school is because of what I've experienced in the family court laws. I've seen firsthand that what is happening to fit parents is not only unfair, but more importantly, not in the best interest of the children. Now, I want to make sure it's clear I'm a law student, I'm not a lawyer. Therefore, I'm not here speaking about joint custody as a professional in the legal field. I'm here to speak of my experiences and observations as a father that's been fighting for equal time with my son for the last 12 years. Just a little bit about my background. I've spent my entire adult life serving others in the military and as a police officer. I have no criminal record. I have no substance abuse issues. I've not provided anybody with any reason to believe that I'm an unfit parent. The events that got me involved in this issue started when I tried to get joint custody in 2019. My son and his mother had lived about 160 miles away from me, but they moved within 11 miles of my house, which made joint custody feasible. I asked my son's mother if she would agree to joint custody, and she said no. So after her refusal, I petitioned the court to modify to a joint custody arrangement, thinking that the laws had changed and that joint custody was now favored. In denying my request for joint custody, the circuit judge said that it would be unfair to punish the mother for moving closer to the father by modifying custody, and held that there had not been a sufficient change of circumstances needed to modify the previous agreement, which that agreement was 9 years old. Before making his ruling, the circuit judge said that he had no doubt that both parents were loving and involved parents, and that both parties were fit parents. The 2013 amendment to 913-101 made it clear that as public policy in the state of Arkansas, joint custody is favored. But if courts are refusing to award joint custody to parents that the court finds to be loving and fit parents, it appears that giving joint custody a favored status did not have its intended effect. Since 2019, I've spent approximately $10,000 in court costs and attorney's fees to try to get something that was supposedly favored in Arkansas. This is money that should have been used to benefit my son instead. The legislature has acknowledged that it's important for children to have frequent and continuing contact with both parents when it's in the best interest of the children. In no way is limiting a fit, non-custodial parent's time with their child in the child's best interest. 2 fit parents should be equally involved in every part of the child's life. They should both be given equal opportunity to bond with the child. These things are almost impossible they are impossible to accomplish when a parent's only allowed visitation every other weekend. The every other weekend arrangement facilitates alienation between the child and the non-custodial parent. It's impossible for a child to treat both parents as if they're equal when the custody arrangement shows the child that both parents are not equal. Whenever I went to court in 2019 and I hired an attorney, my attorney is here and has spoken against joint custody. What I keep hearing is that the laws are working as they are. Well, my attorney's seen firsthand that the laws aren't working the way they should be. If getting this rebuttable presumption for joint custody would ensure that any future parent who wants to be involved in their child's life can be a parent rather than every other weekend visitor. For these reasons, I'm asking for your support for Senate Bill 18, I support Senate Bill 18, and I ask you to do the same. Thank you for your time.
Not on. Next, we have Representative Jay Richardson speaking for the bill.
Thank you, Madam Chair. Jay Richardson, District 78. I'll be very brief. Most of the items have already been shared with you guys, so a couple I wanted to follow up from some constituents. One of the points made in this bill in SB18 is the benefit of the shared parenting provision that places both parents in the equal footing. And we've heard that said already today. And there are many people in my district, as well as an attorney friend of mine, who says that this is definitely a benefit. In addition, it will make it more difficult for an alienating parent to gain or have an upper hand during this litigation. So this bill will alleviate that and give more ownership or give them the opportunity to really work through these issues. Again, thank you for your time, and those are just the comments that I needed to make.
Speaking for Marcus Lewis.
To the committee, thank you so much for the opportunity to speak with you today. My name is Marcus Lewis. I was born and raised here in Little Rock. I attended Parkview High School and graduated from Philander Smith College with a degree in business. I'm an artist and an entrepreneur. I'm married to Andrea Lewis, and we have 3 wonderful children, 2 daughters from my previous marriage and 1 son from my wife's previous marriage. I want to speak with you today about the importance of Senate Bill 18. This bill has the power to mend families and relationships between parents and their children. When I divorced about 9 years ago, it was the hardest experience I've ever dealt with in my entire life. I had spent thousands of dollars on lawyers, and I felt I had failed my children because I was told by a judge I could see my children 4 times a month and speak to them 2 times a week. I was devastated. I went from seeing my children every day to 4 times a month. After numerous attempts to see my children outside my visitation, I was told by my children's mother I would not see my daughters outside of my court-ordered visitation. The last 9 years have been a nightmare. I've attempted to gain joint custody of my daughters 2 times, and I've been denied twice. One may ask, if you've been denied twice, you've obviously done something wrong in regards to your children. That assumption is the farthest thing from the truth. I've never been to jail. I'm always present, always been employed, and always active in my children's schooling and extracurricular activities. So again, why would a father that is willing and able be denied joint custody of their own children? The reason is because the system is broken and it has put money over presence with regard to children involved. In neither of my custody hearings was I asked how many band inquiry recitals have I missed. I was never asked how many visitation pickups I've missed. I was never asked why is it so important for me to be in my children's lives. This type of questioning speaks directly to this bill that states the presumption that joint custody is in the best interest of the children may be rebutted if the court finds clear and convincing evidence that joint custody is not the best interest of the children. We often wonder what is a thread in the fabric of solutions as to how we as a whole can fix so many of today's problems with our youth, drug abuse, murders, incarceration in our schools. One solution is getting our homes and families back in order. Strong family structure is the backbone of our community. Senate Bill 18 is the start to this process. Children need stable and loving environments in order to thrive. Most of all, they need willing and loving parents to help create this environment. We often use the phrase, the best interest of the children. How can a child thrive knowing they only see one parent 4 times a month? Psychologically, this has been scientifically proven to cause various types of anxiety for children. 63% of suicides, 90% of homeless and runaways, 85% of those in prison all come from single-parent households. In closing, Senate Bill 18 isn't about Marcus Lewis. My daughters are 14 and 12 years of age. In a few years, they'll be adults, and my prayer is that I've done enough or said something that will influence them to be productive citizens. I'm here for the parent that cries themselves to sleep at night due to missing their child. I'm here for the parent that eats lunch with their child at school just so they can lay eyes on them outside of their visitation. Most of all, I'm here because all children need both of their parents equally. Senate Bill 18 provides that right and opportunity. I ask that you vote yes for the children of Arkansas. Thank you.
Seeing no questions, thank you for your testimony.
Thank you.
Robin Seacrest. Ms. Seacrest, we don't have displays in committee. Thank you.
You don't have what?
We do not have displays in committee.
Thank you. I apologize for that then. Good afternoon. Thank you for allowing me to speak in support of Senate Bill 18. My name is Robin Seacrest, and Senate Bill 18 is very significant to me. In less than 18 months, my brother, Stephen Barton of Huntsville, Arkansas, went from being a legally married active, involved, loving father of 2 beautiful children to taking his own life this past September 9th, 2020, due to the unsparing family court system that failed him and failed his children. Stephen's utmost happiness in life came as a result of the births of his daughter and his son. He loved his children immensely, proudly shared all of their accomplishments, became a stay-at-home dad for a period of time, played with, coached, and cheered for them. Stephen showed his children affection, mentored them, and provided countless experiences during his time with them. He enjoyed fishing with his son and actually would stock a nearby pond with fish, so when his son came to visit, there was sure to be the excitement of a catch. But above anything else, he just enjoyed spending time together with his daughter and his son. Stephen's children meant everything to him. After 13 years of marriage, Stephen's wife filed for divorce in 2019. She, with an attorney, and he, without counsel, agreed to a settlement order which ultimately led to his alienation from his own children. In his divorce, the custody and visitation provision gave primary custody to the mom and that they would agree on his visitation schedule. However, it stated, in the event the parties are unable to agree upon particular schedules, wife shall have the final say. Stephen's good-natured willingness to be amicable and sign a document he trusted would enable them to move on with a structured, separated family was written by an attorney and signed off by a judge. Within a short time, this order was weaponized to eliminate my brother from the lives of his children because his ex-wife was legally able to dictate when and if he could see and communicate with his own children. With no end in sight, continuing litigation, financial devastation, and strained access to his children, even being excluded from both of their milestone birthday celebrations, Stephen made the fatal decision to take his own life. If attorneys, judges, and the law recognized the importance and value of both parents in the lives of their children, my brother's suicide would have never happened. The rights of fit and loving parents should be protected. Stephen's 8th grade daughter, my niece, and his 5th grade son, my nephew, will now live the rest of their lives needlessly without their father. This could have been prevented if joint custody was truly the standard. Stephen loved his children and they loved their father, and the destruction of their clearly evident loving bond is heartbreaking. It is crushing to read texts and cards from Stephen's children expressing their love for him, pleading for more time with him, and writing how mom knows we really, really want to see you.
I'm sorry, your time is concluded. Thank you for your testimony.
Please support Senate Bill 18 for the best interest of children.
Next, we have Alan McKenzie.
Thank you, Madam Chair and members of the committee. Can you imagine being a physician and recognizing a deadly but treatable disease in your child, and yet you can't get them the help that they need? I don't have to imagine it because I've lived it. Fortunately, by this time last year, with the help of Children's Hospital, social workers, and the threat of DHS involvement, my ex-spouse was finally coerced into getting our 17-year-old daughter the inpatient treatment that she desperately needed in order to survive. This followed months of a downward spiral that my wife and I recognized. Even her principal at Central High School and friend and patient of mine, Nancy Russo, was calling and texting me about getting her help, but we couldn't. You see, her mother is the self-proclaimed ultimate decision maker. And we were powerless until Chandler was so ill that the medical establishment insisted that she go inpatient. At this point, Chandler was 17 years old, 5 feet 4 inches tall, and weighed 87 pounds. Her pulse was in the 30s, and she was at risk of sudden cardiac death. Again, I'm Dr. Alan McKenzie. I'm a family medicine physician and father of 3, Chandler 18, Jet 14, and Beckham 11. I was previously married for 14 years and divorced in 2012. I'm remarried, and my wife is also a family practice physician, and we have the children 26% of the time, and we have no medical decision-making rights, or any decision-making authority for that matter. Primary custodianship for the mother and visitation for the father was the standard when I divorced. It's taken a 9-year battle, hundreds and hundreds of hours wasted, and tens of thousands of dollars spent on attorneys, ad litems, therapists, and co-parenting therapist. And I'm hoping that we're going to get there, but this bill won't fix my problems either. The biggest losses suffered have been by my children. The story about Chandler's anorexia is by far the most extreme example of their mother's reckless behavior that went unchecked, but there are many, many more. Severe asthma exacerbation suffered by my son Beckham due to noncompliance with medication in his mother's house is yet another issue where I had to involve DHS to order her to give him the daily medicine he needed to keep his lungs healthy. Yet another example, my kids were nearly kicked out of school for lack of vaccinations. Now keep in mind, I'm a family doctor and that's the business I'm in, and yet I couldn't help my own children. You, ladies and gentlemen, have the power to make decreased parental rights a position that needs proven with clear and convincing evidence. I never left my children, but I did leave a person who changed. Meanwhile, I've never changed, and I've been there for them the entire time. I left a person who chose alcohol over me, and I became a court-appointed enabler who gives her $4,500 a month in child support that she's used to fund her life while she didn't work for 16 years. I've worked 2 jobs and paid a large amount of child support and provided constant health insurance. Providing for my children is not a problem, but watching them suffer and having no rights to help them is. Joint custody provides checks and balances that would have allowed me to help my children and keep them from suffering medical neglect and psychological abuse for 9 years. It's been a nightmare. Please vote yes for Senate Bill 18. Parents like me need your help. Thank you.
Thank you for your testimony. Gina Indelicato. Okay, she's going to pass. Our last witness is Michael Devine.
Madam Chairwoman, members of the House, thank you for allowing me to speak. Some of which I'll cover or won't cover now has been stated, but I will review, wasn't going to talk from a financial status standpoint, but it's come up a number of times. I'm currently unemployed, but previously have worked on a number of political campaigns, was the manager of a steel plant in Blytheville, Arkansas, which I had about 350 employees that worked for me, and I was responsible for, of course, the plant safety, most importantly, and performance. Before that, I was a resident manager, resident vice president, and senior financial consultant with the firm Merrill Lynch. Graduated University of Iowa, and then attended George Washington University. My family on both sides has been financially fortunate, which sometimes is more of a harm than anything. But from a financial standpoint, when it comes to experts and such, at the end of the initial ruling in my divorce, I paid all the attorney ad litem fees, was ordered to do so, paid all of my attorney's fees, my ex-wife's attorney's fees, all fines and costs. The most important, which is irrelevant really to me, and that was with the help of family, but the most important thing to me is my daughter, who's now 11 years old, Elizabeth Ann. And she was, I'll say, unexpected. I think the term or words were brought up, teenagers will be teenagers. Adults will be adults sometimes too. Met my now ex-wife, just dated 3 months, handed a positive pregnancy test. I'm Roman Catholic. I was given an alternative, and I'd never change that alternative as I have, even though not nearly what I should have as a father. I've got Elizabeth Ann here on this earth. I think the preponderance of the evidence is an absolute ridiculous criteria to meet, because when you run into, and they're out there, crooked, collusional judges who just may not like your attitude or what you have to say, they can use 50% plus feather. And I've had done to me through the court system. I was filed on in June 26 of 2017, so this is still going on. 11 of the 12 judges in my district, circuit judges, have recused themselves from my case. So I'm down to one last judge who it's currently before. Out of the stated chart visits of approximately 2,200 hours you're supposed to have, I have my daughter 210 hours, 8 hours a day, 2 days a month on a Saturday and Sunday. The judges in the past that have now recused themselves made those decisions and are being investigated by a number of agencies and commissions. My daughter, Elizabeth Ann, who used to go to church with me all the time, now thinks that the Catholic Church, per her mother, is a blood church. When I asked her why, it's because Jesus is hanging on the cross in our church, and there's blood trickling down from his hands and his feet from being crucified. I wasn't even allowed to, per the attorney ad litem, take my daughter Elizabeth Ann to my younger twin sister's funeral. About a year and a half ago, she passed away from an aneurysm at 46 years old. Well, I thank you, but it was going to be a sad moment.
Sir, your time is concluded.
Thank you, and I trust you'll support this bill. Thank you very much.
Senator Clark, would you like to close for your bill?
Madam Chair, members of the committee, I appreciate your great patience, but this, I believe, is one of the most important bills of the session. If we didn't have COVID restrictions, I could have filled this area up at least twice with fathers and grandmothers. I had so many grandmothers that said, let me come testify about what this has done to our family from a female's perspective. I'm not going to tell you that all the people who didn't get custody are right. But what Judge Compton said, that she didn't think there was any problem with this, maybe people had sour grapes because they didn't get their way. We have a different relationship with our constituents than they do. They're not all wrong. They're not all wrong. I told you a lot of what they would say. The things that they told me they wanted fixed, we fixed. I didn't think it would matter. I was right. That's why we presented the amendment today. Kentucky cases are down since they passed this, or something similar to it, for whatever reason, by 10%. They act like we would break the system, and somehow the system is perfect now. Like, I'm with the group that thinks, if anything, cost will go down, but they act like money doesn't matter now. They act like there's not a huge imbalance now, and I haven't seen the bar, I haven't seen the judges, love them, I really do, but I haven't seen them do a blame thing about it. I mean, that's one of the things the Senate Chair of Judiciary that just bothers me is the inequity in the system between money and no money. But if you think it's not already there, and somehow this makes it there, that's garbage. People who have had means have spent six figures just to try to get to where this bill starts. Sometimes I speak to young men like Jay Robbins back here who represents the judges, because I've seen it so many times. You know, and you think it's not going to happen to you, but I said, you just don't know. Young men just like you, young professionals, nothing wrong. And the next thing they know, they're on the outside looking in. In this perfect system we have now that doesn't need any changes. The first judge said that it's hard to imagine that judges are ignoring it. I gave you this handout. This is the judiciary until a few weeks ago. The legislature passed a law that said we favor joint custody, but we don't. Hard to imagine that the judges are ignoring it. And then argued time after time against joint custody. I knew that they're skilled litigators. That's what they do for a living. They're good arguers. But Judge Compton said, there is no problem. And I heard this so many times. And then said, but attrition is solving the problem. There is no problem. The judges are following the law, but attrition is solving the problem that doesn't exist. I don't know, math is my strong suit, and that don't work. And then the case we heard, and this is not unusual, because some of these judges are wonderful judges. And what was written down in the case is it's because I hear all the time about best interest of the child. And I catch them and I turn it around on them, because if we cared about best interest of the child, we have and I love the director of DCFS and we work really well together, but they have 1,300 employees, and we had to fight this system because we all knew that visitation would help get families back together, and we only had like 1 hour every 2 weeks, and passed a law that said 4 hours, knowing we couldn't do it. And when's the best time for families to visit? In the evening. But we don't have a night shift, because it ain't about the best interest of the kids. It's about what suits our system, what works for us. I wish it was about best interest of the children. This is about what's best interest of the children. I wish the one therapist who was here to testify, I've never laid eyes on her before. She's the one who'd be closing. Love Representative Gasaway. I'd love for her to present the bill on the floor. Because Marcus Lewis said, what did I do wrong? I can answer that. You're the father. That's what you did wrong. Some of our judges are doing a wonderful job, but not all of them. And when they don't listen to us, they're not listening to the people. This is the right thing to do. We have worked in every way we could to take in all their comments, and everything that they said, we fixed those, and he didn't show it to us, and we still don't want it, and here's the problems. New problems. And if I fix those, there'd be new problems because they don't want to change. As the fact that we passed a bill in 2013 and it hasn't been followed. At least the judge's bench book didn't follow it. So I'm asking you, for the sake of children that need 2 parents, that we start off here. I wish so much that nobody ever split up, that no kid ever had to go back and forth. We can't fix that. They can't fix that. I wish that no parents ever use their children as pawns. That's not their fault. I wish that parents weren't selfish and cared about themselves and rather use their kids to fight with each other. That's not their fault. But it's not everybody, and we know, we have evidence that joint custody actually cuts down on that. And that would be a great thing to do. So I ask you humbly that you give us a chance to do something else, that you give us a chance to do something different, and that we really put children first by recognizing that we should start with 2 parents, and if you can really show good reasons, why not? And there are lots where there are really good reasons, then change it. Because the people said so through the legislature. I trust you to make a good decision. I'd appreciate a good vote.
What are the wishes of the committee? Have a motion do pass? Is that do pass as amended? Have a motion do pass as amended. All in favor say aye. Aye. Opposed say no. No. The bill passes.
Thank you, Madam Chair. Thank you, committee.
Committee, thank you for your good work today. It's been very long. You've been very attentive, and I appreciate your efforts. We are adjourned.